Well, I appreciate you joining today for episode two of Ethical Issues in Real Estate-Based Bankruptcies. This one about insider leases. My name is David Levy from Keene Summit Capital Partners and Summit Investment Management, and I'm your moderator. This webinar is part of the Financial Poise webinar series, Ethical Issues in Real Estate-Based Bankruptcies. Slides 7 and 8 provide a summary of the series and episode. Speaking of the slides, you should understand from the get-go that we will not step through the PowerPoint slides in order, nor will you have to listen to any of us read slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the PowerPoint handy, however, because I will try to indicate what slides we are on in our conversation and as we proceed so that you can take notes. Our panelists today are Samantha Rubin, an attorney from Denton's in Chicago and a member of the firm's restructuring, insolvency, and bankruptcy practice. Matthew Christensen, a certified turnaround and restructuring leader from Amplio in Boise, and he was previously a longtime attorney practicing commercial law, bankruptcy, real property, and business matters. And lastly, Biff Ruttenberg. Biff is a longtime real estate investor and advisor from Atlas Partners in Chicago. Again, I'm David Levy from Keene Summit Capital Partners and Summit Investment Management. We provide real estate services like brokerage, auction, lease restructuring, and more for bankruptcy and other special situations. Our sister company, Summit Investment Management, buys all kinds of distressed debt and provides bridge and bankruptcy financing. But we appreciate that you're not spending your time and money to attend this webinar or hear infomercials about us, but you can read more about us on slides 54 through 57 of the presentation. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions via your web portal. If you're watching this on demand or have questions after the webinar, you can send an email to info@financialpoise.com and just include the question and the name of the webinar episode that you are speaking of, and we will do our best to get you an answer. Special thank you to our co-producer, the National Law Review, a premier legal news website offering in-depth analysis on a wide range of legal and business topics. Okay, as the legendary Jackie Gleason would say, away we go. So today, of course, we're going to have an important conversation about ethics and specifically ethical issues in real estate-based bankruptcies that stem from insider leases. Panelists will speak from different perspectives based on their professional background. Samantha Rubin from Denton's in Chicago specializes in creditor and lender representation, and Matt Christensen, a certified turnaround and restructuring advisor from Amplio, but was previously a longtime attorney practicing civil litigation involving commercial law, such as finance and secured transactions, bankruptcy, real property, and business matters. So for today, he'll play the role of an attorney to the debtor. Lastly, Biff Ruttenberg, the longtime real estate investor and advisor, whose firm aptly states that they help owners who do not intend to be owners. So he will speak from the perspective of a property owner and investor, or in other words, in this context, the debtors. So let's get started. I'm going to jump the deck over to slide 11 as we discuss an important question that brought us here today. What are ethics? Matt, please kick it off for us.
So I would say generally, ethics are the feeling of like doing what's right. So not necessarily what the rules allow, not necessarily what's legal, but just does it feel right? If I had to pass the smell test, am I going to pass, or does it smell a little hinky? So it's just there's different titles for it, but the golden rule, the platinum rule, I've heard, and so just doing what's right.
Thanks, Matt. Biff, give us your thoughts.
I think ethics are very simple. You define them two ways. If you look in the mirror in the morning, are you going to like the person that you see there? Or if what you did was advertised and made public to your professional and personal circles, would you be happy or embarrassed by what was said?
I like it. And, Biff, I have to pay tribute to my late grandmother, who was big on reading us a famous poem, The Guy in the Glass. When you look in the mirror and look at yourself. Samantha, what are your thoughts?
Thanks, David. Yeah, broadly speaking, ethics apply to both lawyers and business people. Sometimes there's actual legal liability there, for fraudulent transfers, someone's trying to usurp a corporate opportunity or unjust enrichment. But sometimes, it might not exactly be illegal, but it strikes someone as questionable. And, we're here in the world of financial distress here where there might be aggressive parties on all sides, and these kind of questions are frequently raised. And when there's an insider involved, there might be fiduciary duty issues and other types of duties that raise a higher level of scrutiny. And so I think we'll get into some of those specific issues today.
Yeah, and from my standpoint, and I'm just a real estate guy like Biff, but I am always mindful of a presentation I once saw from the Turnaround Management Association in Chicago, and it featured the former chief financial officer of Enron, Andrew Fastow. And it was a memorable presentation because he held up a copy of um, Finance Magazine, Finance Executive, CFO Magazine, that was the title. And then he held up a picture of his ID card when he went to prison. And he said he got the same coverage treatment in both of these places from the same set of actions. So he was a hero to CFO Magazine, and then he went to jail. And he explained that when he was serving his sentence, he came to appreciate that while everything he did was approved by their attorneys and it was approved by their lenders and it was approved by their board, and everyone told him he was doing a great job, he knew that the collective effect of all of the actions he was taking was creating a giant fraud, and it was very misleading, and it was also unethical. And so he realized that he knew what the cumulative effect of all of this, and not only was it unethical, but it was illegal. But many people said he was doing well. But as Sammy was saying, we're also going to speak today about legal ethics. Matt, of course, the American Bar Association provides a framework for ethical questions that's referred to as the model rules. And I'm curious, how do the model rules influence your practice?
So the model rules are put together by the ABA, and they get kind of pushed out to the different states. So what happens is each state will adopt some form of the ABA model rules. These are the rules that govern attorneys and the conduct of attorneys. They're rules regarding your communications with your client. There's rules regarding what kind of attorney you need to be, hopefully a competent one. There's rules regarding your communications with other people besides your client, communications with the court, communication with other attorneys, communication with third parties. So every attorney that's licensed anywhere is governed by some set of these rules. And they're enforceable by the states. Basically, you break the rule, you're risking your license being revoked. So they're mildly speaking, fairly important to the attorneys that are governed by them.
And Samantha, how do the model rules influence your practice?
Thanks, David. So one really basic way they influence my practice is, before I file anything in bankruptcy court or anywhere else, I need to make sure that I'm up to date on the rules, whether that's the bankruptcy code or the rules of procedure or even a judge's local rules. That's really important, just staying up to date on, the court and the judge, what's going on. Another classic question that, lawyers frequently ask themselves in real estate situations is, who is my client? Especially where, as we'll talk about in some of our situations here, the landlord might be related to one of the, the major tenants, and, identifying who is the client is really key for the attorneys involved. And then last, sometimes, and maybe this is getting into Biff here, but, when you're representing a debtor, you might be contacted by all sorts of people in a case, especially in larger cases. So we recently had a senior healthcare facility case. We filed it actually 2 years ago, but I'm still getting contacted by, various parties in the case, whether it's former employees or patients, and they're, they don't realize some of the questions they're asking are actually asking for advice. And so you have to walk a tight line and be careful when speaking with unrepresented persons to, you want to help them, but you can't give them legal advice, and you should always direct them to, seek advice of their own lawyer and be careful about how you convey information to them.
Sure. Well, there's quite a few model rules, but today we are highlighting Rule 1.7, conflict of interest, current clients. Rule 1.8, conflict of interest, current client specific rules. Rule 3.3, candor towards the tribunal. And Rule 4.3, dealing with unrepresented persons. And I also think it's important, because we're talking about insider leases, that we talk about the non-statutory insider tests. Matt, would you please elaborate on this concept?
I can, and I want to go back just one step. The insider itself is a defined term in the bankruptcy code. So when the bankruptcy code will have different sections dealing with insiders, that there is a definition in there. If you're an individual, it means this. If you're a partnership, it means this. And so when you get into this non-statutory insider tests, these are the situations where, hey, I've got someone who maybe doesn't strictly meet the definition of insider under the code. Can they still be considered an insider for purposes of whatever is happening to them? Whether it's an avoidance claim, whether it's a claim objection, whatever. So the courts around the country have developed different non-statutory insider tests, and there's a closeness test, a control test, a similarity test, but generally what the courts are looking at is the specific facts of that case, right? Is there a relationship between the debtor and this party that is close enough that we're going to say you're basically an insider, even if you don't meet the statutory definition, or that you, the third party, are able to somehow control the debtor in a way that we should treat you as an insider. And so these are ways to sort of expand that little bubble of statutorily defined insiders and say, okay, you may have structured your deal such that you don't qualify as a statutory insider, but you're so close and have so much control, and the debtor really can't do anything without your permission, that we're going to consider you an insider and therefore open the door for whatever it is that's being done to you.
Thanks, Matt. Well, and Samantha, how do leases play a role in bankruptcy? Certainly a big part of our practice, where they have to be restructured, but I see it all the time that there is a piece of real estate that happens to be owned by the debtor, and they happen to be running their business out of it, and they happen to have created a lease. Please elaborate on this.
Leases can be either an asset or a liability. If it is likely to be an asset if, one, you have a very profitable store at that location. Two, you have a below market rent, where in theory you could sell that lease to somebody else. You may, extreme example, you may be selling luxury goods in a middle or lower middle class neighborhood. I don't know why you went there in the first place, but you're the wrong retailer for that market. But because you were a big name, somebody made you a very favorable deal, and a more appropriate retailer would love to have that deal that you've got because it's below market. So that becomes an asset of the estate. The rules got tweaked 6, 7 years ago on how quickly you could dispose of those leases, now to decide what to do with it. They're much shorter now, so the debtor is required to fish or cut bait. The good thing about bankruptcy is if that lease is a liability, you have an unprofitable store, the rent's too high, the store's too big, the store's too small. That lease is considered what's known as an executory contract. Each party, the landlord and the debtor, have to provide something in the future. Tenant has to pay rent, landlord has to provide the space, and executory contracts can be terminated. So if it's a liability and you don't want it, bye bye, Mr. Landlord. And the code has very specific provisions on how to calculate the landlord's damages and what the limits are. And since most cases return far less than 100 cents on the dollar to unsecured claims, landlord is going to be getting a lot of money back at some point.
Samantha, do you have anything to add to this? How leases play a role in your bankruptcy matters?
Yeah, I would just sort of add on to what Biff said, and sort of to state the obvious, there's a clear tension between landlords and tenants in real estate cases. And we've seen retail cases sort of slowed down for a bit a couple years ago, but in 2025 we saw a big increase in filings. And so, like Biff said, for a retail debtor who has lots of leases, it's sort of a superpower in bankruptcy where you can reject the lease. You can't necessarily do that outside of bankruptcy. So if the lease is above market, or maybe they have an underperforming store that they want to close, that's an option for them, something they can do in a bankruptcy case. But yeah, that's it.
Okay. Well, let's put this all into practice now with some ethical situation case studies from a few actual cases and a few that are hypothetical. I'm going to jump ahead to slide 20 here as we get into a case in re Scott Acquisition Corp. Scotty's Inc. is the wholly owned subsidiary of Scott Acquisition Corp. Prior to their bankruptcy, Scotty Inc. and Scott Acquisition Corp., which are collectively the debtors, were retailers of a building materials and home improvement products company for the do-it-yourself home improvement market. The defendants were the individual officers and directors of Scotty's Inc. We'll just call them Scotty's. The complaint alleges the defendants' misconduct as follows. Scotty's entered into a loan and security agreement with Congress Financial Corporation, we'll call them Congress. Under that agreement, Congress loaned Scotty certain sums of money and took a security interest in substantially all of the debtor's property. Scotty's, however, was unable to make the required loan payments. As a result, Scotty's and Congress made various amendments to the loan agreement. During negotiations relating to the loan, Congress expressed its desire to have Scotty's divest itself of its real estate holdings and pay down the amounts owed to Congress. This would not only reduce the amount owed to Congress, but would also allow inventory to be the sole focus of Congress's security interest. Having inventory as the only collateral would allow Congress with a quick exit strategy, payment on potential Scotty's liquidation. As such, Scotty's began divesting itself of its real estate holdings on a sale and leaseback basis. Some properties were sold to independent third parties. Others, however, were sold to entities controlled by certain of the defendants. These insider defendants, through the controlled entities, paid less than fair market value for Scotty's choice real estate. In return, Scotty received no more favorable treatment on the terms of the leases than it would have with third parties. Throughout, Scotty's failed to solicit and consider third-party offers for the purchase of its choice real estate. Further, Scotty's failed to seek any independent consideration or review of these insider and leaseback transactions. Accordingly, the complaint alleges that the defendants, the officers, and the directors of Scotty's breached their fiduciary duties of care and loyalty in several respects. The complaint also alleges that the defendants had knowledge and rendered substantial assistance with regard to one another's breaches of fiduciary duties. Okay, Mac, given this fact pattern, what ethical issues do you see?
So the biggest one that jumps out to me is the both, I guess, two issues: the sale price and the leaseback terms being not reasonable. So the especially where it's the choice properties, whatever that actually means. The choice properties were sold for less than fair market value, but the lease terms were market lease terms, essentially. That dichotomy, I think, is the biggest problem. Failure to solicit other third-party offers for that same choice real estate, failure to get any sort of outside review is an issue. So from an ethics standpoint, I would want to know what role the attorneys for the company played in those negotiations and documenting that purchase agreement. The attorney for the company represents the company, so represents Scotty's. It doesn't represent the owners. It doesn't represent the purchasing entity. And so what duty does that attorney have to Scotty's to tell Scotty's you're getting a horrible deal and you need to have some third party look at this thing? And did those attorneys do that or not? If they didn't, then arguably Scotty's has some Scotty's and or the acquisition corp that's the parent company may have claims against those attorneys for ethical issues and or malpractice. So, but those are the biggest ethical pieces I see is what role did the attorneys play in that whole negotiating process?
Thanks, Matt. Biff, what ethical issues do you see in this case?
Well, the first issue, of course, is failing to get any third party validation or verification. If you're going to do a sale leaseback with clearly insider parties, um, you the phrase is CYA. You need to paper it. So you'd at least want to get appraisals of the real estate. What's a fair price for the real estate? Uh, you'd want to have some third party statements as to what's an appropriate rent. And typically in sale leaseback, the rent is a financial rent. I want an 8% return on the sale price. We call that a cap rate in real estate, which may or may not represent a market rent. So you need to look at both what's an appropriate cap rate, what are outside investors willing to accept for this kind of real estate and this kind of obviously at this point questionable credit, but also is that a market rent for the property here? And they clearly didn't do any of this. What the insiders were doing was saying, Scotty's isn't going to make it, and we want to keep the goodies for ourselves at the end of the day. Whether the lawyers even knew what how the economic terms were derived is a separate question. Uh, I would take the view that the lawyer's not there to negotiate the business deal. The lawyer's there to paper the deal. So I tell Matt or Samantha, here, the purchase price is $1 million. The rent's 80 grand. It's a triple net lease. Document it. And how I got to those numbers, that deal, that's what LOIs are for and letters of intent or business documents, in my view, not legal documents. Because if you start bringing lawyers into LOIs, A, you're going to slow the process down. B, you're going to make it more expensive. And C, you run the risk of that LOI starting to look an awfully lot like a binding contract, which you don't want to have.
Thanks, Biff. Samantha, what can you add to this?
Yeah, Biff and Matt did a good job of covering the ethical potholes here. I would just point out, the main point here, I think, is that the process matters and how they conduct the process of a negotiation and coming to the price really matters. And clearly they haven't really run a fulsome process like we would normally see, failure to market the property to third parties and consider any other offers. They could, to help themselves out here, they could maybe have an independent director or advisor or even get a fairness opinion. Those can help as well. And I have seen judges deny, real estate sale because, there was a lack of marketing or, soliciting other offers to third parties. So they could certainly improve their process here.
Well, Samantha, variation on what you were just saying, what if we change the back pattern and the insiders actually had an unsolicited bid from a third party, but they refused to negotiate with that third party? How does that change things?
This changes things. This is certainly another flag. It would depend what number that bid came in. If it was so low that it was offensive, they shouldn't even consider it, then that would raise less of an eyebrow. But if it met or exceeded the insider lease amount proposed, that's definitely a bad look. It looks like they want this deal done for themselves, for their own benefit, not to actually, not for the benefit of the property. So this could be, so maybe a breach of fiduciary duty here, failure to look out for the company's best interests, and putting their own self-interests ahead.
Thanks, Samantha. Matt, please give us your thoughts on this one.
I agree with Samantha. I think it's probably a worse bad look if the unsolicited bid was higher than what the insider's purchase price was. If it's the same, then the duty, I guess, is more, did you go to the insiders and say, hey, we have this other bid and you guys need to pay a little bit higher? Probably not, because the insider is the one that got the third party offer, and that's why they wanted to keep it quiet. So I think the fiduciary duty that the insiders have would be different depending on what the actual nature of that third party bid is. But I agree with Samantha. If it was a lower bid, right, then there wasn't any need to respond, other than potentially going back to them and saying, look, your bid's super low. We've got an offer that's higher than that. Do you want to outbid that offer? Or maybe they would have, and then you so.
Biff, anything to add to this?
It's always a bad idea not to respond to an offer, even if it's a low ball. Someone may be thinking, gee, I can steal this real estate because the company's in trouble and they need money. But if you go back to them and say, well, we'd like to talk, but you got to get real. The failure to engage in conversation, particularly when the third party objective lender is encouraging this process. This wasn't, gee, we're going to explore strategic alternatives. And if it works, we'll do it. And if it doesn't, we won't. You've been encouraged by your lender to do this. You got to talk to people. This is not liking what you see in the mirror, and certainly not wanting your friends to hear what you just did after the fact. It's all bad.
And Biff, let me give you one more variation. What if the insider had an unsolicited bid from a third party, but instead co-opted that third party to be an investor in the insider deal?
That's just worse. Now they know it was bad, but they wanted to get this guy away from rocking their boat. And so by co-opting him and getting him, so as to speak, to pull an oar in their boat, what they've done is get him out of the way and sweeten their own deal to the detriment of the retail customer. This is variation 2 on this screen is even worse than variation 1.
Samantha, what do you think?
Yeah, I think this deal is tainted. From the attorney perspective, it's all about appearances. Would a reasonable person think that this is collusion or that this is unethical? And, here I think it is. And it really just shows all the ways that having insider deals can create issues. And you really have to be mindful of who the insiders are and make sure you paper everything.
David, I would call this the duck example. If it walks like a duck and quacks like a duck, it's a duck.
I hear you. Matt Christensen, any final thoughts on this case study?
No, I think Samantha and Biff really touched on everything. I like the duck analogy.
That's what I was trying to say.
Matt, the focal point of our program today is about the model rule. So talk about model rule 1.7, conflict of interest, current clients, and how that model rule might apply to this case study.
So rule 1.7 is the basic, thou shalt not represent the same parties in a transaction rule. It prohibits representation of one client if there's a concurrent conflict of interest, which means representing one client would be adverse to the interest of the other client, or there's a significant risk that the representation will be limited because of the attorney's responsibilities to a different client or former client. So in this context, with this case study, if the attorneys for the company were involved in the negotiating, were involved in the drafting of the purchase agreement and the lease back for the insider transaction, and then this case comes up because there's a lawsuit that gets filed by the company as plaintiffs against the defendants. And so if that same attorney is now representing the company in that lawsuit, or even worse, that attorney is now representing the insiders in the lawsuit, that's a very clear violation of Rule 1.7. You were involved in the discussion that happened. You were involved in the transaction. And so realistically, you're more of a witness in that lawsuit than you should be an advocate for one or the other client. So I think these are the sort of situations that are difficult for attorneys. You may be the attorney with the most knowledge about that transaction, and the one best suited to represent the company and what it expected to happen. But realistically, you can't, because your representation would violate 1.7. I think I think the next one will get a better situation for the sort of company versus owner representation. So I'll leave that.
Okay, good lead in. And I'm going to advance us here to slide 24. And we'll talk about case study number 2, which is Inree Edgewater Medical Center. The background is Chapter 11 debtor in possession brought adversary proceedings against its landlord and their common principal to set aside alleged fraudulent transfers and to recover on breach of contract, breach of fiduciary duty, and other theories. The bankruptcy court, Judge Black, held that 1, no transfer of interest of the debtor in property occurred of any kind potentially subject to avoidance upon expiration of the debtor's purchase option under the lease. 2, debtor failed to show it was insolvent or rendered insolvent by challenged rent payments. 3, landlord breached covenant of good faith and fair dealing. 4, debtor's chief executive officer breached his fiduciary duties in allegedly obtaining inflated appraisals of leased property that debtor had option to purchase at its appraised value so as to ensure that debtor would not exercise this purchase option, and that lessor, another corporation that the CEO controlled, would continue to collect allegedly exorbitant rent. 5, debtor was entitled to specific performance of option as well as return of rent. 6, punitive damages were warranted. And 7, doubts about whether debtor was prevailing party counseled against attorney fee award. Okay, Samantha, given this fact pattern, what ethical issues do you see?
Thanks, David. I'm glad that this case is in our presentation because it has quite remarkable facts, and I think hits home to a lot of the issues of insider leases that we want to convey to our listeners. So first, I just want to have, I'll make a couple points on the ethics, and I want to call out some interesting facts here. So as some background, this is a Northern District of Illinois bankruptcy case, which is sort of my home turf. And the trial lasted about 5 weeks. Near the end of the trial, the defendant CEO, the landlord CEO, fired his lawyers and then proceeded to flee the country. That's never a good fact pattern. And so even though he had fled, the judge decided to rule on the merits, despite him not having any lawyers anymore. He probably just had enough facts after the trial had finished. But so the entity at issue was a hospital with some adjacent properties that were owned by this insider entity, and the CEO of the hospital owned that entity 100%. The entity had the option to purchase the adjacent properties, but he did not do that. He failed to exercise that option, which could have avoided future rent payments, and then that's when this lawsuit filed. So one of the main issues was those appraisals. Those 2 inflated appraisals that the CEO got to, instead of finding a third-party neutral appraisal that was market He showed the board these two appraisals to convince them not to exercise their purchase options. Basically, so he could keep, getting inflated rent, which clearly is not in the best interest of the company here, and it really is in his self-interest. So I'll start there, and I think Matt and Biff will have other things to add.
Okay, Matt, what do you got?
I think there's another interesting fact too. So not only inflated appraisals, but the leased property, I think in the opinion, the court referred to it as like the adjacent property, was a whole series of different things, different buildings. And the purchase option, the option was to purchase all of that property. So there wasn't an opportunity to sort of pick and choose. I want the three pieces that we need, but the other stuff I don't need, we don't need to purchase. So it was sort of an all or nothing option, which I think also affected the debtor's ability to exercise that option. So not only was it an inflated appraisal value, but there wasn't any option to purchase just the necessary pieces and sort of let the rest go back. So from an ethics standpoint, I think, again, what role did the attorneys play in this? Did the attorneys know that those appraisals were inflated? Maybe, depends on how good of a real estate attorney they were. At the same time, I mean, at a certain point, you have to be able to trust the appraisers to give you good appraisals. So the knowledge of the attorney, I think, matters in this case.
And Biff, what do you think? What was this guy thinking?
Well, the whole, again, this whole deal smells because the CEO was trying to bleed the medical center uh, for his own benefit, for the benefit of the real estate. Um, Most qualified commercial appraisers carry a designation, MAI, which means member of the Appraisal Institute. We in the trade sometimes rename those initials to stand for made as instructed. I don't want to impugn every or perhaps even any appraiser, but it's very difficult when someone leans on you to say, I need this number, not to be able to come back with that number. It's the classic show me the feasibility consultant who says the project isn't feasible, and I'll show you a consultant who doesn't get hired next time. But this was a rape and pillage of the medical facility for the benefit of the CEO. And the proof is in the fact that the guy took off and left the building, left the country. Elvis has left the building. I think that real estate sat for 10 or 15 years before it was eventually redeveloped into something else because it took so long for all the litigation to wind its way down.
And Biff, what if we change the fact pattern? And it turns out one of the lenders to the hospital was an investor in the CEO's other corporation, but no one advised the lenders of that fact.
Wait, the lender was an investor in the hospital or in the real estate?
He was in the lender. One of the lenders was one of the lenders to this hospital was an investor in one of the CEO's other corporations, but no one advised the lending group of this fact.
Well, that's a horrible conflict because where is the lender going to come down if there now are discussions amongst the lenders? We should take course A or course B. We should foreclose or we should forbear. The lender who has an interest in other things with the CEO is clearly going to be more inclined to be lenient, even if the facts relating to his collateral dictate taking a severe approach. Again, bad course of action. This is a classic case, which is why we're talking about it, of course, of unethical behavior and unethical actions that exposes everybody, particularly in a bankruptcy, to litigation risk.
And Samantha, do you have anything to add to what Biff was saying?
Yeah, I think I'd want to know some more facts too. This could certainly make the lender complicit in collusion here, but I'd want to know more about what the facts say, what the evidence are, what the evidence is. The lender would probably have the financials of both entities too, which would not be a good fact for the lender.
Sure. Matt, anything else to add to this one?
No, I think the next fact pattern or change is more interesting for me.
You mean like, what if the insider sold the lease into a securitization and then pockets the proceeds for other businesses?
Yeah. So this I think goes back to sort of how we got here, right? That the case exists because there's an adversary proceeding filed by the debtor. If the lease was transferred even further, sold to a securitization group, then you get that added layer of, you're not the initial transferee anymore. Now you're a subsequent transferee. Were you a good faith purchaser? Do you have that bona fide purchaser status? Was there what disclosure was there in that transfer that, hey, this is based on an inflated value? Presumably the securitization group is doing some due diligence onto this loan or this lease that they're purchasing. Did they get copies of the appraisals? Are they savvy enough to recognize that those appraisals are inflated? And so what knowledge did that group have? So does that change in the fact pattern change the analysis? I think yes, it makes it even harder. Because now you're getting into all kinds of disclosure issues that whether they did or didn't happen. And if they didn't happen and they didn't need to happen, and they do have that bona fide purchaser status, then you're really stuck. And maybe you can go after that owner for the proceeds that he received from the other group. But if he already reinvested them in a different company, then you got a whole nother layer in there. So it gets interesting.
It sure does. Biff, what's your hit on this change?
This becomes a very difficult situation because if, as Matt said, the securitization is deemed to be a bona fide purchaser, a BFP, then they can't be attacked because they had no knowledge and they were clean. You then have to try to chase wherever he went, the CEO to glom out of the proceeds. And one has to assume if he fired counsel and fled the country, he knew where foreign banks were. And the proceeds may very well have followed him offshore. And now you have a real mess. This may be a situation where you're simply dead on arrival in terms of trying to recoup any of the proceeds.
Great points. Samantha, any final thoughts on this case study?
Yeah, I agree with everything they've said. There's certainly a chasing the money problem, makes it harder to collect or get anything back. And then, the second part of the question is, what if he's pocketing that money and using it for other businesses? Certainly that would be commingling. That's not a good idea under, I don't know if even has an operating agreement, but it certainly would not be good look for any fiduciary duties or duties he has to this company, to use even if it was not good, he sold it into the securitization, he probably has some sort of obligation to use those proceeds for the actual business, and not for his other businesses. Who knows what they are? Maybe he's investing in something in France, who knows where he went, what he's using it for. So that money might be long gone.
Sure. Samantha, get back to the model rules, the all-important model rules. Let's talk about model rule 1.8, conflict of interest, current clients. Current client specific rules. How would this model rule apply to this case study?
Sure. So this is an interesting model rule, and I think it's one that people often forget about, especially as they work closely with their clients over time and, really get to know them and their business. So Model Rule 1.8 deals with business transactions between a lawyer and a client. And, over time, the lawyers, builds trust and confidence between, him or herself and the client. And you might have possibility of overreaching when the lawyer participates in the business, whether that's, investing or, loaning money to the client. And so the goal of the lawyer is always to put the client's interests above, him or her own interests. And so here, if the attorney of the CEO had also invested in the business, this could raise a flag. Maybe the attorney is approving transactions or giving advice in order to improve the financial outlook of the company, instead of maybe telling the CEO, hey, what you're doing is not, there could be some violations here. So it really muddies the waters. And so when a lawyer has invested in the company or has some other connection to the client, they have to be careful to make sure that their advice really is for the client and not in their own self-interest.
Okay, well, with that, let's go to our next case study here, which is INRI 148 South Emerson Partners, LLC. And this was a case that was in the appellate division of the Supreme Court of New York in 2018. Summary is that four business partners, Drew Dozier, Michael Meager, Michael Meyer, and Stephen Smith, formed a company to operate a restaurant. Collectively, they are Emerson Associates, and a separate company to own and lease to Emerson Associates the property at which the restaurant operated. This is Emerson Partners. Years later, Meager, Smith, and Meyer, holding a combined 75% interest of Emerson Partners, voted to evict Emerson Associates from the property, which Dozier opposed. Dozier presented a lease that he argued governed the landlord-tenant relationship between Emerson Partners and Emerson Associates. However, the lease was undated, and the signatories on behalf of Emerson Partners and Emerson Associates were not identified. Dozier provided no evidence that the lease was ever presented to Meager, Smith, or Meyer, or even any correspondence regarding the lease existed. Further, while Emerson Associates paid rent and real estate taxes and liability insurance for the property, as well as constructed $1 million in improvements to the property, Dozier could not provide evidence that such payments were made pursuant to the lease, or that Emerson Partners knew it was accepting payments pursuant to a lease and the terms of the lease did not match. The court thus determined that no valid lease existed between Emerson Partners and Emerson Associates. Okay, Biff, what are the ethical implications of this insider lease agreement?
Well, this isn't an insider lease. This is four guys opening a restaurant that don't know very much about real estate and even less about business. Maybe they were four chefs. You can't, I mean, it's incomprehensible to go open a restaurant on what amounts to a month-to-month tenancy, which is what they had, because they never reduced their agreement or even their understanding, loosely defined, into a document. And if it turns out maybe the restaurant associates wasn't making as much money as everybody hoped, and the real estate had appreciated in value, then maybe the three guys who agreed to terminate weren't in the food business, but were investors. And the fourth guy was the chef. He wanted to run his restaurant, but the restaurant wasn't making money, and the guys wanted to repurpose the real estate. I mean, this is, again, why we're talking about it. In a case, this is a level of insanity. You just don't run a business without a lease, and there couldn't have been a lease because there were no terms. To have a deal, you have to have an offer and an acceptance that's somehow documented, because real estate has rules that require all agreements to be in writing.
Good points, Biff. Samantha, what do you think?
Yeah, I think Biff, did you go to law school? Because you're hitting on some of the things they teach us the first year.
I've been around enough years that I've been accused of it before.
It is very important to document everything. There is this rule called the statute of frauds, where certain types of contracts must be papered, otherwise they are unenforceable. They teach you that in first year contracts, and this is why. It's impossible to tell what's actually, what the parties actually agreed to because it's not in writing. And, from a legal perspective, I can understand why the court found that there was no lease because the court needs, as much set in stone as possible. And here, there really just wasn't enough. Maybe there was an oral agreement. But at the end of the day, the court is the fact finder. And also maybe it was 3 versus 1. There were three really, commercially savvy guys, and then the one guy was the chef with the vision here. And so the court maybe just found, the majority wins here.
Thanks, Samantha. Matt, what do you think?
I think the same thing from as what these two both already explained. I think from an ethics standpoint, I would have two questions. One is when they first set up this arrangement with the two separate companies, did they have an attorney assist them with creating Emerson Associates and Emerson Partners? And did that attorney know that there was going to be a lease arrangement? And did that attorney tell them you're going to need a written lease? And they just ignored all of that? Or did the attorney ignore it all and say, well, I'll help you set up the LLCs, but you're on your own as far as anything else goes? So that would be interesting for me to know. And then the attorney representing Dosher in this thing, trying to present this evidence of a lease to the court, if it's undated and unsigned and the dispute is now several years later, the attorney's got a really uphill battle to get the court to accept that lease as the agreed lease between the parties, because he knows it's unsigned, he knows it's undated. That there was a finding in there that the terms of the lease, which I think are the terms of the written agreement that he presented, and the actual rent, actual real estate taxes, actual stuff paid, didn't match. So he knows that the performance didn't match what the term in the lease was, yet somehow he's arguing to that court, this is the lease term that was in place. I think there's a pretty big flirtation with the candor to the court when he's making that argument, and or potential Rule 11 issues, which is a whole different topic. We could probably spend a whole hour just talking about Rule 11. So I think there's some significant ethical issues for the attorneys.
And going back to Biff, what if we change the fact pattern here? And Biff, what if there was an email chain confirming the terms of the draft lease, which the lawyer had in his inbox?
It still doesn't make it a lease. I couldn't remember the name of the statute of frauds that Samantha referred to, but if it isn't in writing and signed, it isn't a lease. It could be construed as an oral agreement, which gives you a month-to-month tenancy, but a month-to-month tenancy can still be terminated. If there in fact was an email chain and the lawyer didn't follow through and generate a lease, the next thing that lawyer will do is pick up the phone and call their malpractice carrier because they got a problem.
Thanks, Biff. Matt, what do you think? How does this alter things?
I agree with Biff. I don't know that it changes it too much. It's not that the email chain just tells me they talked about doing a lease at some point. And maybe there's even an email in there where the lawyer says, you need to get this all drafted and put in writing. That maybe protects the attorney from a malpractice claim. But bottom line is the email chain is not a lease signed by all the parties.
Very true. Samantha, anything else to add to this change in fact pattern?
Yeah, if I was that attorney, I would have a little bit of anxiety, especially if this took place a couple of years ago, because I would want to try and remember what happened after that. Was there a phone call where they said, stand down, we're not doing this lease? Or did the attorney simply forget to forward it to the other side to sign? You would think that the other side would have followed up on it, but you never know. So I would just want to, really run that down.
Sure. And how about one more? Samantha, what if the lawyer had a copy of the draft lease? It was signed by one, but not both sides of the transaction. How does that change things?
Well, probably doesn't help here because the court found that the lease was not ratified by the parties' behavior. So, especially if it's only signed by one and not the other, if there's no ratification, that's not helpful. But maybe if there was an email afterwards, let's say the agreement wasn't actually signed, but they emailed them back and said, hey, this looks good. Or some sort of confirmation. And maybe this was a pattern. This is how the parties tended to do business with each other. They just sort of, one person signed and the other one said, yep, that's fine. So maybe there could be some facts here that make this a contract.
And Biff, from where you sit, does this get us closer to having a lease?
Oh, get you closer, but bad analogy, I apologize. It's like being pregnant. You either are or you aren't. You have a lease or you don't. Being closer to it still doesn't get you to a lease. There is still no lease. And from a business standpoint, the fourth partner who wants to continue the operation really doesn't have a leg to stand on. And I would take the position, if I'm that party, and that I would want to turn to my lawyer and say, this is my fault. This is your fault. You didn't get it finished.
Matt, how does this fact pattern strike you?
So I'm going to answer in true attorney fashion by saying it depends. The 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 fact pattern changes. One party signed the lease. I think if we go back to the parties, the two parties to the lease is Emerson Associates and Emerson Partners, right? It's not the four individuals, it's the two companies. And so if the party that signed the lease is Emerson Partners and it was Meager, Smith, or Meyer who signed on behalf of Emerson Partners, I think then you've got a really good argument that there is a lease. And even if it was signed by Emerson Associates, but one of those three guys was the one who signed it on behalf of Emerson Associates, then what you have is at least two of the four partners either consenting or arguing that there was a lease in place. Even though one of them changed his mind later and now is arguing that there wasn't, even though he's the one who signed the document. So I think depending on how the signature was, that could change the outcome.
Very good point. Starting to run short on time here, but
I
Samantha,
would take that expert witness assignment adverse to Matt's position.
Samantha, as we start to wrap it up here, please speak to the applicability of Model Rule 4.3 dealing with unrepresented persons to this case study.
Yes, so 4.3 deals with when, there's an unrepresented person in a deal or a matter, and there's a lawyer who represents a different party, and the lawyer is supposed to know that unrepresented person, they're supposed to help them and say, I'm not your lawyer. They need to make reasonable efforts if that person thinks that they're their lawyer. So here, one of the possibilities is that, the Emerson owners, maybe three of them had a lawyer and one of them didn't. So if there are any communications between the lawyer for some of the Emerson folks, they would need to be very careful in their communications with the one unrepresented Emerson person.
Sure. Well, we are pretty much out of time here, everyone. So I just want to take a moment to thank Samantha Rubin from Denton's, and Matt Christensen from Amplio, and Biff Ruttenberg from Atlas Partners for sharing their time with us today and helping us work through some very interesting issues from their experience. I will also let the audience know that you can find the text of all these ever so important model rules that we've been covering. If you want to look at slide 40 through 51 of the presentation. This concludes our webinar. Thank you for joining for another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. And we hope to see you for episode 3 that handles single asset real estate cases. Thanks, everyone. Take care.
Thanks, David.
David.